is a New York City law that makes it a crime for police officers to impair an arrestee's breathing during arrest unconstitutional? To find out, you have to read PBA versus City of New York, but it's 15 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Police Benevolent Association of New York City versus City of New York. The citation for this case is 2023 New York Slip Opinion 05960, published by the New York Court of Appeals on November 20th of 2023. The issue in this case is whether a New York City law prohibiting police officers from impeding an arrestee's breathing during an arrest is unconstitutional. To appreciate the context of this case and where it fits in the law, you have to understand a couple of different things. First, with respect to the legal matters, the New York State Constitution has several provisions, but two of them that are important in this case is the Due Process Clause and a Home Rule provision in the New York State Constitution, which is found in Article 9, Section 2. And that basically says that local municipalities, cities, towns, villages, can adopt laws relating to government protection, order, conduct, safety, health, and well-being. So they can make laws about any of those areas. But, and this is a big but, there's a big exception here. They cannot make laws if it's preempted by the state. And I'll explain what that means. Basically, municipalities cannot adopt laws in areas that are preempted. There's two kinds of preemption. There's field preemption and there's conflict preemption. Field preemption says that the New York State Legislature has assumed full regulatory responsibility in the given area. So they can show it by the legislature saying that they have field, that they've created a full regulatory system. They can do it by enacting a comprehensive and detailed regulatory scheme, or from the nature of the subject matter and the purpose and scope of the laws, that there's a need for statewide uniformity. If any of those things apply, then there's field preemption, and the local statute cannot enter that area that's been field preempted by the state. And the other area is called conflict preemption. And that's basically where the state specifically permits something that a local law prohibits. So if the state says you are allowed to do X, then a city can't say, well, you can't do X, because the state has already said you can. It's been preempted by conflict. The other aspect of the Constitution we have to understand is there's a due process clause that says that it's basically fairness. And for criminal laws, a criminal law is constitutionally infirm. It's unconstitutional under the due process clause if it's vague. And there's a two-part test to determine if a statute is vague, a crime is vague. First, with respect to the fairness to the criminal, and the second is the fairness to the enforcement agent. So the first question is the statute sufficiently definite to provide a person of ordinary intelligence with fair notice that the conduct is forbidden? So would the purported criminal know that this is forbidden? And the second step is whether it provides officials, to the enforcement agents, with clear standards of enforcement to avoid ad hoc or subjective enforcement. So is it sufficiently definite and clear to the purported criminal and to the purported law enforcement agent that would be prosecuting this offense? Okay, so what are the facts in this case? The facts are that in July of 2014, we probably all know this, there was a man named Eric Garner who died during an arrest in Staten Island, which was recorded by people nearby, and it made national and international headlines. During the arrest, the police used force on Mr. Garner, who repeatedly said, "I can't breathe," over and over again. After that arrest and death, the New York State Legislature passed a specific law, Penal Law Section 121.13a, which makes it a crime, a felony, for police and peace officers who cause serious physical injury or death through the use of certain restricted restraints, including chokeholds. But in 2020, and this is what this case is about, in 2020, the New York City Council went even farther than that Penal Law 121.13a. This new law by New York City Council says that it's a misdemeanor in New York City for any person, this is really for police officers, any person to restrain an individual in a manner that restricts the flow of air or blood by compressing the windpipe or the carotid arteries on each side of the neck, or sitting, kneeling, or standing on the chest or back in a manner that compresses the diaphragm in the course of effecting or attempting to effect an arrest. So if a police officer impedes an arrestee's breathing by standing or sitting on the chest to a way that compresses the diaphragm, then that's a violation of this new law. The PBA, the Police Benevolent Association of New York City, filed this lawsuit saying that this law was unconstitutional because A, it violates due process, it's too vague, and B, it violates the home rule provision of the New York State Constitution because of field preemption and conflict preemption. So the Supreme Court that gets this case grants summary judgment saying it is too vague. It goes to the appellate division, they reverse it, finding it is constitutional. It goes to the Court of Appeals, and here what we have is they basically analyze the two different areas that we just talked about, applying those same rules we talked about. As to the home rule provision, they say, the question, is it preempted? Well, first of all, right, the statute says, or the home rule provision says, a locality can pass its own laws unless it's preempted. Is it preempted? They say no. There's no New York State regulatory system in place that would create field preemption, and there's no statute allowing an officer to compress someone's diaphragm that would be conflict preemption. So it does not violate the home rule provision of the Constitution. And as to due process, they say it is sufficiently definite to give fair notice to the purported criminal, and it is sufficiently definite to give a sufficient standard to the law enforcement agency that would prosecute it. And therefore, it is not unconstitutional, meaning it is constitutional, and summary judgment is granted in favor of the City of New York. The law is fine and valid. That's the case of PBA versus City of New York. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.